Hi, good afternoon, everyone. My name is Michael Bittoni, and I'm an attorney with Callagy Law's New York Medical Revenue Recovery Department. Today, we'll be talking about counteroffensives against the top 3 tactics that insurance companies use to deny claims. Most of us have had the experience where you have a patient come in, they're seriously injured after a car crash, they really need treatment, and then you find out for some reason that the insurance company thinks that the claim shouldn't be paid. Perhaps because they say that the care wasn't medically necessary, or because they think that the patient has already resolved all of their conditions. A lot of these kinds of defenses that insurance companies raise can be anticipated and dealt with in advance. We'll share some strategies so that you can decrease the risk of getting a medical necessity denial during the claims process, and we'll talk about ways that you can improve your record keeping and patient care practices to increase your chances of winning at arbitration or litigation. I hope everybody feels really excited about this because this is one of the most important topics that we need to talk about in the world of PIP denials. A lot of these tools that insurance companies use, they use them all the time. They're very, very, very common. Although that does present risk to a practice's revenue, the fact that they are so common and that they're used in such a routine manner is an opportunity for us. That is an opportunity for us because it means that we can predict what the insurance companies are going to do, and we can take steps proactively in advance to protect our revenue and to increase our chances of winning at arbitration and litigation if the claim has to go that far in the first place. So let's talk about the 3 top tactics that insurance companies use. And we'll talk about each one at length. First, I'll name all 3 of them. First, this is the simplest issue for us to deal with in record keeping and the claim submission process. Insurance companies may say that a patient's care or injuries were not related to the car crash that the patient says that they're seeking care for. And I'll say that again. The one-word answer there is causation. Insurance companies may say that a patient's conditions weren't caused by the accident. Another reason that insurance companies will say care was not medically necessary is they'll say that there was a deviation from the standard of care that isn't supported, or they'll say that the care doesn't match the standard of care. So number 2, a deviation from the standard of care that's not supported, or the standard of care was correct, but the patient didn't show the signs and symptoms that would have put them into the cohort for which the care should be provided. Number 3, an independent medical examination by an insurance company doctor may show that the patient's conditions have fully resolved or that they need a lower level of care than your practice is offering. Number 3, an independent medical examination, called an IME in insurance jargon, may show that a patient's condition has fully resolved or that the additional care that they need is less intense than what your practice is offering. Let's talk about different ways to anticipate each defense that an insurance company can raise, how to head them off in the first place, and how to set ourselves up for success if the claim goes to arbitration and litigation. First, we'll go through causation. Causation arguments are frequently raised when a patient has a degenerative condition. This is often infuriating, and when we think about the policy implications of saying that people with degenerative conditions who have been hurt in car accidents shouldn't get care because their condition was pre-existing, we see how really crazy this is. People with degenerative conditions generally have higher risk for injury. So if an insurance company says that they don't have to pay because a patient's condition is degenerative and pre-existing, that means that patients who are most likely to get hurt in a car crash may be less likely to get access to care. Fortunately, the legal standard for proving a causation defense is very, very high and recognizes the fact that people with degenerative conditions and other kinds of pre-existing conditions are at heightened risk. The legal standard is the insurance company must affirmatively show that there was no exacerbation of a pre-existing condition because of the accident. In addition, medical providers generally get the benefit of having causation presumed. So if you have a patient come in and their condition, say a herniated disc, preceded the accident, and they now say that they feel worse, there's a good chance that if the claim goes to arbitration or litigation, there will be a presumption that the accident exacerbated their condition. The key word there is exacerbation. And it's important to take a really good patient history. This is how we're going to anticipate and improve your chances of being able to deal with a causation denial. It's important to anticipate that somebody with a pre-existing condition or a degenerative condition may be flagged by the insurance company for causation review. So when somebody comes in and you see that they have a pre-existing condition, or maybe they're just an older patient and they have some normal degeneration in the spine or in the joints, maybe they have some tendonitis or other common issues that you see in older patients or patients who have had repeated injuries to a certain area of the body without regard to their age. These are the kinds of patients you want to say, okay, this is somebody that the insurance company might send for causation review. In the medical records, it's really, really important to take a detailed patient history. Sometimes if a patient's presentation seems really obvious, they have MRI results showing, say, a multi-level disc herniation, really symptomatic, they're disabled, they can't work, they are having trouble with their ADLs. We may be tempted to skip how they got to that point because they're so obviously injured. But taking a really detailed history based on what the patient can tell you can be incredibly helpful. So if you see somebody with these kinds of conditions, pre-existing, degenerative, maybe somebody's older, take a really detailed patient history. Make sure that you ask the patient about whether they were asymptomatic before the accident, when their symptoms began, and if their symptoms were worse after the accident. Sometimes patients may say that their subjective level of pain goes up and down. It's important to ask extra questions about a patient's subjective presentation if their sense of how sick they are or how hurt they are goes up and down, because we need to be able to show that the accident did exacerbate their condition. It doesn't have to be a lot. If somebody had a condition that they feel created a 5 out of 10 level of pain for them, and after the accident they have 5.5 or 6 out of 10, then that's usually sufficient. So be aware that certain kinds of patients are likely to get flagged for causation review, and make sure that you take really good notes on the patient history. If you have a patient where you're not sure based on their history exactly what's going on, it's maybe a little bit difficult to find causation, it may even be worth it to reach out to the patient's previous treatment providers to find more objective evidence other than patient's report about how they were before an accident and how they are after an accident. So, for example, if you have an MRI after the accident and you can see that this patient is seriously hurt and needs treatment, but it's a little bit unclear from the patient's self-report that there was an exacerbation, see if you can get some earlier MRI results or talk to their earlier treatment providers and see what they can tell you. The time spent doing this can be really worth it, because remember, if a patient is found in arbitration or litigation to have a condition that is not caused by the accident, that claim will not get paid. It'll get denied completely. And insurance companies really like the causation defense because although it's a very high legal standard, it means that medically necessary care still won't be payable by their PIP carrier. So to sum that up, identify patients who are likely to go to causation review, make sure that you take a really good detailed patient history, and if anything isn't clear from the patient's history and the medical records that you have, talk to their prior treatment providers and see if you can get more objective evidence showing or corroborating the exacerbation after the accident. Okay, does anybody have questions about that so far? And you can ask a question by using the chat screen or by raising your hand using a speak request. Okay, let's move on to talking about an insurance company's arguments regarding the standard of care and deviations from the standard of care. Usually, these kinds of arguments will be raised in a peer review. You'll get this long, usually it's a long document, 10, 20, sometimes even 10, 20 pages, sometimes even longer, that might cite to all kinds of different medical publications. But the bottom line is that a doctor hired by the insurance company has looked at all of their medical records, and they're either saying that this patient didn't qualify for the care that you have already provided, or that whatever deviation from the standard of care wasn't justified. This is very, very, very common. Very common. And to show you just how common this is, I want to tell you an anecdote about someone that our office met who actually writes these documents. And let's take a poll. There are doctors whose entire job, day after day, is to write peer reviews assessing whether care is medically necessary. How many medical necessity reports do you think a single doctor hired by an insurance company would write in a single day? And you can say your answer, you can type your answer in chat. And if you're not sure, that's okay. Just ballpark. How many reports do you think a doctor would write in a single day? Okay, well, whatever number you're thinking, it's pretty high. We talked to a person who said that they wrote over 50 of these reports in a single day. I don't know how many of those reports led to a finding that the care was not medically necessary or was an unjustified deviation from the standard of care. But the volume of these reports is really, really high. Insurance companies are really good at getting these reports. They bust them out at high volume, and you have to deal with this because those reports on their own will give the insurance company a basis to deny the claim. It's a little bit more difficult to prospectively figure out what kinds of patients are likely to get a review. I will say anecdotally that pain injections very, very frequently get peer reviews that find lack of medical necessity. And I'm speculating a little bit here, but I think that's because of the exponential growth in the total cost of pain injections in the healthcare industry. There are a lot of benefits to them, but the fact that they have grown to encompass such a significant portion of the expenses of car insurance carriers gives them an incentive to try to figure out how to eliminate some payments for pain injections. Surgeries often get denied based on peer reviews. However, it's much less likely that a surgical procedure will be upheld, that a surgical procedure denial will be upheld even when there's a peer review. Usually there's significant evidence showing that somebody needed surgery, but not always. So how do we deal with this in advance? One of the ways that you can do this is you can actually include a statement of medical necessity in the medical records themselves. This will help you in two ways. First, it will satisfy one of the legal requirements for showing that you provided care that's consistent with the standard of care, or that if there's a deviation from the standard of care, it will articulate your medical reasoning about why. Many providers do have statements of medical necessity that are basically exactly the same from case to case to case, and don't provide any case-specific analysis. They'll say something like, I am a professional in this particular field, I have reviewed all of the evidence, and in my opinion, the patient needs the care that's described above. Generally speaking, that's better than not having a statement of medical necessity at all, but it's just barely better. It's something instead of nothing, but it's not very helpful in avoiding getting a peer review in the first place, and it's not very helpful in the arbitration and litigation context. So a small modification to your record-keeping practices can give you a much stronger chance of having your claims paid and of prevailing in arbitration or litigation. Now, there are some complexities to how to articulate medical necessity in a legal setting, but the core questions that are often asked, and again, this is not advice for any particular case. Different practices have different needs, and different patients have different cases. So before you make any specific modification to your practices, you should consult with us on a one-on-one basis. But so you understand the kinds of questions that are often looked at in a legal setting and that you may want to include in your patient records, it can be very simple. I had an arbitrator, for example, tell me once that many of the best physician rebuttals aren't long scholarly documents. They're maybe one paragraph, or maybe even no more than 3 paragraphs. And there are just 2 to 3 basic questions you need to answer. First, what is the standard of care? Second, was the standard of care followed? And if so, apply the standard of care to this patient's case to show how it was followed. Third, if the standard of care wasn't followed, or if the patient's case is very complex, explain why the standard of care shouldn't apply. Then describe the medical reasoning and facts that led to the decision to provide this particular treatment. It doesn't have to be long, and it doesn't have to be time-consuming. If you take just 10 minutes to write 1 or 2 paragraphs about this, that is really significant in many, many cases. In fact, there are some insurance companies that have internal processes where if a doctor writes a medical necessity statement that's good, or writes a rebuttal providing answers to these same questions, if it was for some reason excluded from the medical records, a lot of insurance companies have internal processes where they will actually reconsider a case for settlement or payment on the mere fact that this is even in the file. Peer reviews are usually most effective when there are medical records that record a patient's diagnostic imaging and clinical examinations and objective findings, but don't necessarily show what the standard of care is or what the doctor's medical reasoning is in a way that is comprehensible, and this is the key point, in a way that is comprehensible to a lay person. It's a little bit insane that this is the system that we have, but you need to understand that medical necessity determinations in the PIP context are decided by 3 lawyers in a room most of the time. There are many different kinds of proceedings, and sometimes there are witnesses, and sometimes there's expert witnesses. Sometimes there is a doctor on each side. You might have a medical coder on each side. You might have a billing person versus a claims adjuster. They can get very, very complicated. But your typical claim that goes to arbitration is decided based solely on the medical record, on the insurance company's peer review, if a peer review is the basis for their defense, and it's the provider's attorney, the insurance company's attorney, and then a neutral arbitrator who is also an attorney. So yes, medical necessity will be determined by 3 attorneys in a room in many cases. So have a brief statement that in understandable, comprehensible lay language explains the answers to these questions. What's the standard of care? Was it followed? And if so, show the facts and medical reasoning that apply the standard of care to this patient. And third, if the standard of care wasn't followed, why not? And explain the facts and medical reasoning that justified a deviation from the standard of care. That can go a long way. If you have cases that have been denied and sent to arbitration or litigation, I want everyone to seriously consider writing rebuttals. Rebuttals are important. Remember what the arbitrator, who I just mentioned, told me. Some of the best rebuttals are 1, 2, or only 3 paragraphs. If you know a case really well, you can do that in 10 or 15 minutes. And if you have a claim for $5,000 and you're spending 15 minutes writing a rebuttal, that means those 15 minutes, prorated on an hourly basis, are worth $20,000 an hour. The claim has already been denied, and you can potentially significantly increase your chances of prevailing if you spend just 10 or 15 minutes. If you could make $20,000 of revenue in an hour, wouldn't you do it? Of course you would. Writing rebuttals can feel tedious, and putting these kinds of medical necessity statements into your records can take extra time. But this is important because medical necessity denials are a highly effective volume tool that insurance companies use all the time to threaten your revenue. And the tools that I'm giving you here are effective weapons to anticipate and counterstrike against these insurance company tactics. They're worth a lot to you. If you choose not to use these tactics, it's like saying I'm going to go up against somebody who does have a weapon and I don't want body armor and I don't want my own weapon. You can fight back against these kinds of denials and you can protect your revenue. It's important. If you have questions about how to do it in particular cases, and like I mentioned, different kinds of practices may need to make different kinds of statements about medical necessity and standards of care, contact me directly. My telephone number is 201-261-1700. I'll also give additional contact information at the end of this video. Let's talk about the third kind of common tactic that insurance companies use. IMEs, in insurance jargon, or in everyday language, independent medical examinations. Now, this is a bit of a misnomer, and if you've been watching these webinars, you'll notice that I've analogized a lot of the insurance company terminology to the Holy Roman Empire, which has been said to be neither holy nor Roman nor an empire. And an independent medical examination, similarly, is not independent. An IME physician or practitioner is hired by an insurance company to do this review. It won't necessarily be medical because there are different kinds of specialties that IMEs can be performed in, and it won't necessarily be a medical doctor doing it. And to say that it's an examination is a charitable way to describe many of these reports. So earlier we took a guess about how many peer reviews a single physician could write in a single day. And let's do another guess. An IME will actually see the patient. A peer review just looks at medical records and that's it. But an IME actually sees the patient. So given that difference between a peer review, which just reviews medical records, and an IME, where the patient actually is required to go in and have an appointment with a doctor or other practitioner, how many patients do you think an IME provider will see in a particular day? And you can put your guess in chat, or you can just have a number in your head. So and remember, they see the patient and then they have to write a report based on their findings from the patient examination. How many patients do you think an IME provider would see in a single day? Okay, everybody have their number in your head? I've seen IME sign-in sheets, and these practitioners will see upwards of 80 patients in a day. 80 patients in a day. IMEs are also highly effective. Peer reviews have to be tailored to a specific episode of care. For example, if a patient gets a pain injection, then a peer review for that pain injection will deal just with that date of service. However, an IME is designed, in most instances, to see if a patient still needs treatment at all. This means that if a patient goes, Menorca answered 30. No, 80. 80. The volume is incredibly high, and it's important for you to understand that this is a war that the insurance companies are fighting against you, but you can arm yourself with good practices. This is a volume war, and the volume of denials is very, very, very high, but with good practices, you can prevail against the majority of these denials. Okay, so let's deal with IMEs. IMEs can be really, really tricky for a couple of reasons. First is that, since an IME is a patient visit designed, in most cases, to see whether the patient still needs care, a negative IME finding can cut off care prospectively. If a patient goes to an IME and the IME finds that this patient is no longer injured, they don't get any more care under that policy at all. That's it. It's over. However, you can protect yourself from this. Because IMEs see so many patients in a single day, the reports are often very, very low quality. However, it is an expert opinion from a doctor or other practitioner who has actually seen the patient. That means it can get significant weight. And to illustrate how significant the weight can be for an IME report that is not specifically rebutted by the provider, by the treating physician, I'll give you a pretty unbelievable example that I found shocking, but actually is not even that uncommon. There were two separate cases where an IME reviewed medical evidence showing that the patient had a symptomatic disc herniation. The IME then performed a clinical examination and concluded that there were no range of motion deficits, no neurological deficits, and that the diagnoses were soft tissue injuries which had been resolved. Now, this obviously should be some kind of misdiagnosis, and if this patient is having a good day, perhaps they just took their medication, perhaps they just finished a pain injection. There are a lot of reasons that someone might present and not immediately seem to be injured. But the bottom line is that diagnostic imaging shows symptomatic herniation, and the IME reports in these two cases found resolved soft tissue injuries only as the only diagnoses. Unfortunately, both of these IME reports were upheld at arbitrations, and we lost those cases. I'm telling you this to highlight, first, how effective IMEs can be if they are unrebutted, but also to highlight the incredibly low quality of these kinds of reports because they're drafted at such high volume. Run some of the numbers. If an IME is seeing 80 patients a day and they're working, say, 10 hours a day, they're spending less than 10 minutes with a patient, maybe just 5 minutes with each person. They're not doing a comprehensive quality review. This means that although an IME report that is unrebutted can be highly effective solely because it's an expert opinion, arbitrators know that these reports are frequently very low quality. And I'll tell you another anecdote. I had an arbitrator describe to me the way he feels when he has to find in favor of an insurance company's report that's unrebutted, where there's nothing in the medical evidence to specifically rebut the IME's findings. He said, sometimes I have to hold my nose when I award these cases in favor of the insurance company. This is an opportunity. This is an opportunity for you to arm yourselves and fight back against IME denials. And there are a couple of ways to do this. First, generally speaking, the legal standard to deal with an IME is that you need contemporaneous medical evidence that rebuts the IME's so-called objective findings. So, for example, if an IME report says that a patient has no neurological deficits, but they have numbness and tingling, it's important for you to make sure that you have evidence of that in the patient file. Sometimes a facility that's submitting a facility bill won't have the documents from a patient's clinical examination. They might just have an op report and very limited records. If you're a facility and you're dealing with an IME denial, it's very important for you to obtain medical records from the treating physician that fully elaborate the patient's objective presentation. If you are the treating physician and you're dealing with an IME denial, you can do a lot to deal with the fact that there's an IME report. First, the fact that you are a treating physician means that your examination of the patient is almost always going to outweigh the IME physician's examination of the patient. But it's important for an examination to be contemporaneous. Usually the standard that arbitrators and judges look for is contemporaneous evidence within 30 days of the IME. Now, that can be very, very frustrating because maybe the patient has finished treating, maybe you have a very, very busy calendar, and you say that, well, this patient has already received their treatment, or I have to squeeze them in for a medical office visit and clinical examination that I've already done, and that doesn't make any sense and that doesn't need to be done again. Yes, it needs to be done again, and you've got to get this patient in most cases. Because the consequence of not doing that is that the ridiculous, horrible quality IME from this physician who saw the patient for 5 minutes and asked them to wave their arms around and then found that their symptomatic disc herniations have resolved, that's going to be the report that determines the case. If there's no evidence contemporaneous to the report that rebuts the so-called objective IME findings. So have the patient come in again. You need evidence, objective evidence, within 30 days of the IME to rebut the objective findings. If for some reason that's not possible, maybe the patient has finished treating, maybe they've relocated, or there's some other logistical problem and you can't get this additional examination, then it's worth your time, again, to write a rebuttal. In this rebuttal, it doesn't have to be long, but look at the so-called objective findings in the IME report and just show and highlight the clinical evidence that shows that those findings are wrong. If the IME says that there's full range of motion, look through your medical records and find places where range of motion was restricted. Or if the IME finds that there's no further care needed because of something like a range of motion test, but actually range of motion isn't the appropriate test that should be performed in the first place to identify whether a condition is symptomatic, then highlight that. There are a lot of ways to attack these reports. And if you sit down with one, if you sit down with 10, if you sit down with 50, you're going to see that they are full of holes. It doesn't always take a lot to fight back against IME denials, but it does take something. And remember, the 10 minutes that you spend, if that's worth $20,000 an hour and it gets your claim paid, that is something that is going to protect a lot of revenue for your practice. Okay, so the takeaways for today. It's important to take really, really good notes about a patient's history, whether they were symptomatic or not before a car crash, when their symptoms began, and if they were symptomatic before a car crash due to a degenerative condition or a pre-existing condition, then you need to take detailed notes about how their presentation changed after the car crash. And actually, I realized something I forgot to mention when we were talking about causation is a reason that insurance companies will often use to flag patients for causation review is if they don't go to the hospital after a car crash. That's a common trigger for a causation review. Now, there are a lot of reasons that somebody might not go to a hospital. Maybe they don't have adequate insurance. Maybe they're in shock. Maybe they're not really aware of their pain yet. Maybe their pain gets worse and they don't need to go right away. They have lots of adrenaline in their system. They're not feeling too bad. Maybe they just want to go home and rest. There could be many, many reasons that patients don't go to the hospital. But if they don't go, then an insurance company is going to look at that and say, this is a foot in the door for us to potentially deny this claim. So add that to the list of reasons to anticipate possible causation review. Okay, so takeaways from today. You want to take really good notes about how the patient is before and after the accident. If you can't get great information based solely on the patient's self-report, then try to obtain evidence from other treating physicians before the accident. When dealing with peer reviews, you want to consider including a statement of medical necessity in your medical records. It doesn't necessarily have to be long. And if it turns out that what you have in your records isn't sufficient, if your claim goes to arbitration or litigation, your attorney can work with you to get something that will help you with that case. But it's important. Spend 5 minutes, spend 10 minutes. That can really, really protect you against a lot of these denials. And remember, you can't just say, I'm an expert, the care is necessary. It has to state the standard of care, and it has to apply the standard to the patient. Or if the patient has a complex case, then you need to explain why you deviated or provided some kind of novel treatment strategy. Third, with IMEs, if you can, get the patient in for your own examination within 30 days of the IME. If that's impossible, you can write a rebuttal highlighting the medical evidence that will rebut the so-called objective IME findings. Does anyone have questions? And you can type your questions in chat, or you can raise your hand. And I see Rosie is asking to speak. Okay, Rosie, you may be able to speak now. But if you have any tech difficulties with your microphone, you can also type a question in chat. Okay, I don't hear any audio, Rosie, but you're welcome to type a question in chat. And I'm also going to put my contact information in chat, and you're welcome to contact me directly. Again, my name is Michael Bittoni. I'm an attorney with Callagy Law's Medical Revenue Recovery Department for New York. My telephone number is 201-261-1700, extension 1040. And you can also send me an email. I'll use a phonetic alphabet to spell my email address. It's Michigan, Bravo, India, Tango, Tango, Ontario, November, India, at callagylaw.com, CALLAGY.com. And you can also connect with our firm on Instagram, Facebook, LinkedIn, and YouTube. Thank you so much, everyone. If you have questions, feel free to reach out. And I'll send the recording of this webinar to you in an email to be sent out in the next day or two. Thank you for coming.